Thank you all for making me really feel welcome here this morning. It's freezing. I was born in Quebec City, which is the snow capital of the world, and I played hockey until about 20 years of age, so I lived and almost slept on the ice, but this takes the cake. Yes, it's true. I've been married, in fact, soon 51 years, and I take pride in it because I have an absolutely lovely wife, and we tend to do everything together, and we're very proud and very happy together. But I'm becoming more and more unhappy and lonely because when she meets people, she tells people she married me when she was 10 years of age. It's difficult to be aging alone. I'd like to pay homage to Sir Wes Hall for your inspired and very remarkable presentation this morning. I think what you had to say is universal. I wish we could bring you home and speak to Canadian audiences, but you'll have to put a hockey jersey on and trade your cricket bat for a hockey stick. But if you're prepared to do that, we're prepared to have you. It's a pleasure to participate in your annual conference on anti-corruption. I'm truly honored to speak among such distinguished guests and speakers. I want to say that apart from being inspired by the privilege to be here, I am struck by the visionary leadership of your organization, which reach beyond conventional decision zones of governance. I am also truly impressed by the quality and the diversity and courage of the individuals members of the Board of Directors of Transparency International at the Trinidad Tobago office. I'm also, of course, mindful and in awe of the productive and sincere relationship between the TI and the British Council in both in a pursuit of a common pursuit, I should say, of a common goal that require both passion and conviction, and I've seen manifestation over the past 2 or 3 days of this in spades. Though whistleblower has become a hot topic almost everywhere, certainly that I travel to, and particularly in Canada, most reports of whistleblowing, particularly from government sources, tend to be superficial and paying lip service to the thought and the results and the benefits from it, and very little to address the fact that whistleblowing and the report of corruption, in fact, is done because it corrodes the democratic institutions themselves and make a mockery of repeated political promises to do actual reforms. However, the significant expansion of whistleblowing activism teaches all of us to demand true and authoritative and authentic recognition and protection for the truth tellers, as I like to call them. I don't call them whistleblowers, I call them truth tellers. In my experience, whistleblowing is an irresistible and unstoppable force which can only grow in significance and importance because it is concerned with the most honorable goal, that is the protection of the public interest and the respect for the rule of law. These are two sine qua non of a true democratic society. My purpose here this morning is to discuss what whistleblowing protection legislation should look like. My recommended approach is based on the Canadian experience, and I can go into more detail if required during the question period, which hopefully would follow. My purpose also is to engage in a dialogue with you so that we can explore together some areas which are a concern when we are on the threshold of trying to adopt or develop some whistleblowing protection legislation. Over the past 2 days, I've had the opportunity to meet several leaders within the Trinidad Tobago government, and they are all part, from what I can see, of a puzzle board designed to provide your country with the tools and resources to stop or to reduce the flow of corruption. Together, they form, at least in some cases in the embryonic stage, a very impressive first step and a strong basis to receive and investigate complaints from whistleblowing. This will happen, of course, once legislation is in place to extend a protective arm to welcome and to look after whistleblowers. In the meanwhile, however, the agencies, be they the the Police Complaints Authority, the Integration Commission, and the Finance Intelligence Unit, should be seen as a very potent and a very welcome pioneers in the fight against corruption. And that's where they are at the moment. Let me open by noting that a trusted legislative disclosure regime for the identification and disclosure of wrongdoing for the purpose of investigation, correction, enforcement, and prosecution needs to focus on 4 essential fundamentals. First, the legislation should make it clear that whistleblowing is a right. I can call a duty, but it is a right to disclose all illegality and misconduct. The legislation should be standalone and something like what you have in Japan and Korea. It should apply more specifically to both the private and the public sector. The legislation should be broad. It should apply to all illegality, gross waste, gross mismanagement, abuse of authority, dangers to public health, and to the contravention of any policies, regulations, or laws. There must be no loopholes. This includes any wrongdoing, whether it occurs within the legislative, the judicial, the executive, the police, or the military, and within the private sector. In other words, there will be no refuge or no sanctuary for a wrongdoer and corruption, period. Second, whistleblowers must be provided with the means and the channels to make protected disclosure. Perhaps Australia have it right with their approach: when in doubt, report, as it reinforces the commitment to employees for their concern of wrongdoing, or for employees that their concern of wrongdoings are taken most seriously. Third, whistleblowers must be provided with legal guarantee that if they are acting in good faith, they will not be dismissed, suspended, demoted, disciplined, or otherwise disadvantaged by reason of having made a disclosure. The issue here is that harassment of any kind will not be tolerated. Fourth, whistleblowers must be provided with a financial remedy should his or her career be jeopardized, be shortened, or be plateaued. This means that whistleblowers must have access to courts of justice, not just internal remedies, and be saddled only with a realistic burden of proof, meaning that once whistleblowing shows that there is a nexus between the whistleblowing itself and retaliation in a temporal or contemporary fashion, then the burden shifts to the employers to demonstrate that it was not harassment. Otherwise, it would be impossible for the whistleblower to prove that it was retaliation for his action. I believe, and I hope that we will all agree, that effective legislative whistleblowers protection is absolutely essential to encourage the reporting of misconduct, fraud, and corruption. I hope we will also agree that the legislation should provide, if not an incentive to the whistleblower, at least a guaranteed for protection of his economic interests and the protection of his reputation and privacy. I hold the firm belief that legislation protection for a whistleblower is a matter of public importance and a matter of public interest. Whistleblowers are of an inestimable value to government at every level, whether at the federal, in Canada context, federal, provincial, or municipal, but they also of value for university, churches, charities, and of course, non-profit organizations and businesses or commerce generally. Whistleblowing facilitates the prevention and, where applicable, the discovery and reporting of instances of bribery, fraud, and even other forms of wrongdoing. The person who is acting in good conscience and whistleblow, it protects, in fact, government because it allows them to deliver cost-efficient programs, to support a clean and fair business environment, and to call out those who may be tempted to operate below the radar to achieve their unlawful deeds. Now, before moving on to provide you with what I consider some additional essentials for a robust and effective whistleblowing protection legislation, allow me to say a few words about whistleblowers in particular. Regardless how repugnant and scandalous the observed misconduct may be, person acting in good conscience and in good faith will always think twice, long and hard, before stepping forward to denounce corruption. Why? Because the strain and the risk associated with whistleblowing are incalculable, and you can predict them. Sometimes it will take the shape that you had not anticipated. Whistleblowing is not for the faint of heart, and nor for the careerists who place self before the public interest. The whistleblower is a very special breed. He or she is prepared to cast aside the bonds of loyalty and trust as soon as, and as well as the safety and comfort of the harmonious relationship he may have had with his employers or co-workers. And that happens as soon as he opens his mouth or as soon as he makes a disclosure. He knows from the day of his disclosure onwards that his career will most likely take a nosedive, and his reputation will also probably be compromised. And yet the whistleblower is prepared to come forward, face the consequences of his action that will have an impact upon the remaining of his career or maybe even the remaining of his life. And he does that because he believes strongly that the public interest and the press of his conscience requires him to do that. The contest between wishing to act upon the press of his conscience to report wrongdoing and at the same time having waves of apprehension concerning the likely or possible retaliation or harassment or dismissal that he will have serve more often than not as a very strong proponent. So people will come close to the start line and will back off. Or they'll make a very timid disclosure part of it to try to alert authorities, and then they'll back off. So any legislation on whistleblowing protection has to be, as another essential, has to be constitutional or quasi-constitutional in nature, so that the protection of whistleblower is universal and acts as an override over different laws, whether they be criminal statute, freedom of information laws, labor laws, or laws regulating, for instance, public broadcasting. This legislative approach should allow for the same rules and procedures, and they should apply both to the private and the public sector. Another essential rule is the reporting mechanism. Potential whistleblowers must be made aware of how and to whom to report misconduct, fraud, or corruption. This means there must be a clear reporting procedures and channels in place to facilitate this reporting. And reporting can be done either in person or through legal counsel. Now, the person or body designated to receive such disclosure must be perceived as having two overriding characteristics or qualities. One, to be and to have unimpeachable integrity, and second, to have viable and real powers to receive notice of disclosure in confidence and have the fiduciary duties to act upon such disclosure, whether the disclosure concerns commerce, manufacturing, construction, procurement, utilities, you name it. It doesn't really matter. In my experience, the individual or the body that receives and is seen as the sort of safe island or safe conduit to receive instances of wrongdoing and disclosure of such must have either one or the other, either strong prosecutorial experience and knowledge or a judicial background. Someone with a recognized high level of probity, capacity to face dangers and obstacles to arrive at concrete results, that's the person that you need to have, in fact, to carry the flag. The selection of that person is pivotal to the success of a real whistleblowing program. If you don't have the person from the start, people simply will not go to him or her. There is no doubt in my mind that such a person must have some qualities that we refer to, and I use word as fearless, a dedicated person, someone who has the backup of a team of experts in law, police, banking, as well as, if required, to be provided with a close-in type of security so he can do his job effectively and fearlessly. The model which I have in mind for the kind of Hollywood type of individual who could do that is, back in the 1930s, Elliot Ness, who basically carried a gun and carried a fight to the Chicago hoods and was able, in fact, to make sure that justice prevailed and the bad fellows were put in jail. The special prosecutor or counsel should, in my mind, report not to the executive nor the legislative. It has to have free rein, it has to have a direct link, and that direct link should be to Parliament. In Canada, we have an institution whereby we refer to them as Officer of Parliament. So it's multi-party, it is not partisan, it's outside the bureaucracy, outside the judicial, outside also the legislation. And why? Because he needs to be seen as the protector of a country's values, heritage, and the rule of law. A third essential characteristic is feedback. I believe it's essential that once wrongdoing is reported, that an appropriate investigation be carried out, and that the whistleblowers be provided with some form of regular feedback. I think, having taken all the risks and dangers associated with coming forward, he or she is entitled to that much. And the feedback is the only positive aspect that he has to, in fact, secure his decision-making of having stepped forward. It will give him the strength to him and his family, colleagues, and people, in fact, who will support such a courageous action, as giving the strength and the trust in the system. In other words, not only are they taking it seriously, but they're acting on it. The fourth essential is that the legislation must, in fact, have procedures and have a scheme by which clearly, if proven, the allegation, the individual, the whistleblower, will not suffer any type of retaliation, and those who does, in fact, will pay the price. In Canada, our criminal law provides for such sanction. So somebody, a whistleblower, is retaliated against, either in the private or public sectors, it's a criminal offence, and those who do so, particularly employers, are prosecuted. A fifth essential is the oversight of the Whistleblowing Protection Office, an office whereby the individual who's been a whistleblower can report to and basically be safe and be taken in hand and provided with the type of support that he needs. And one of which is, during the complaint mechanism and procedure, which could extend over many, many months, then he should be provided with independent legal counsel. Somebody who can look at his interests, somebody who can advocate for him, somebody who, if required, may have to go to court on his behalf to take on either government or whatever employers that happens to be. One point that I need to make is that, in my mind, whistleblowing is not the rule, it's the exception. And I believe that whistleblowing legislation and whistleblowing protection legislation comes after certain other essentials are put into place. I think it's unfair for any organization to rely upon the existence and the manifestation of whistleblowers in order to basically to clean up their act. If we look at it, and if any one of us can put yourself in the shoes of whistleblowers, it's a most unfair system where you require somebody, be that person a nurse or a finance clerk or a lawyer, I've seen all of those, to step forward in order to denounce and to pay the costs, and perhaps, perhaps his labor and his courage will be for naught. And what you need to have in place, I would say, before you get a whistleblowing legislation and whistleblowing protection legislation particularly, you need to have at least 3 systems in place. First and foremost, you have to have an effective police forces. I'm not playing judgment here. I'm just saying a police force. And every other nation that I deal with, I've got not only a police force, but you need somebody to police the police. And unless you have that, easier said than done. We've gone through in Canada a RCMP, a Mounted Police External Police Complaints Commission, and it didn't work. And rapidly the message got out, and as a result, any one of you who monitors the international press, you will see that we have in fact, we have a bit of a scandal with RCMP sexual assault and sexual harassment. Individuals trying to move their complaint to the RCMP External Complaint Commission will not receive any satisfaction. So it's being changed now, but until that happens, then we're not going to have as an effective police force, and you're effective as a police force if the people trust that you are independent, impartial, and effective. So how do you get there? You get there because you need 1 or 2 additional issues. One of which is a working Freedom of Information Act. In Canada, we have 50,000 requests a year. From where I'm sitting, 50,000 requests, it means that we have 50,000 whistleblowers. People who ask, they don't really ask for records. They ask for records because they want to exercise their right to know. And once they have the records, our Supreme Court has said the rationale, the raison d'etre for an access to information regime is twofold. First, to give the ordinary citizen a right to know so that he can exercise his electoral choices. And second, so he can be held accountable either the elected officials or bureaucrats. I can recite here 30, 40 what would be referred in the media as scandals that their origin were as a result of an access request, or 1 or 2 or 3 or 4 being put into the system. That was whistleblowing of the best kind, and it produced a result that we're all looking after. The next and important part of the triad, when I'm talking somebody to police the police, freedom of information, then the next one is a vigilant, investigative journalism system in place. They can do the job. all of which taken together reduces the size of the population, expected population that will become eventually whistleblower. As I said, it's the exception rather than the rule. Let me conclude. Providing whistleblowers with effective legislative protection is not an easy task. It first requires an authentic and unreserved political will, and I haven't seen that manifested in my lifetime in many, many places. We're paying lip service, but have we really got a political will to do this? Second, it must also provide the whistleblower with the unfettered conviction that robust and anti-corruption initiative to detect and combat corrupt acts, fraud, and mismanagement are now part of the political landscape. That's easier said than done. As noted earlier, several countries, including my own, have passed whistleblower protection legislation. In reality, however, whistleblowers, if any, few of them actually rely on it. And they don't rely on it because they do not have the confidence that governments really want to have these reports of whistleblowers. What they want to have, and what our own legislation in Canada does, it forces the whistleblower to go through to his own chain of command and reporting channels. Now you ask yourself, why would a whistleblower want to do that in the first instance? Because that's what he's done. The reason why he metamorphosed himself into a whistleblower, because his call for support, for reform, for investigation have gone nowhere. So our own program requires them to do that. In some cases, and I'll close on this, if you don't have the proper type of whistleblower legislation, you will be worse off. Whistleblowers who no longer have unimpeded access to the media. Whistleblowers would no longer be able to be protected against a certain degree of naivety on their part by disclosing. They will be forced into a regime which, in Canada in particular, says that any issue that is a subject of a whistleblowing disclosure now becomes protected and falls outside the reach of the Freedom of Information Act. So you're blocking access then to the media, and you're blocking access to the bureaucracy to try to correct their own things. So, in conclusion, whistleblowing is a very noble, a very courageous, and it's not for the faint of heart, and it should be the exception rather than the rule. Before you get there, one of the things you have to make sure that works in concert with, and perhaps even on top of, is the Freedom of Information Act. That is absolutely essential. There are 93 countries in the world that have them. Some are very effective, others less so. I can refer to the one in the US that I work and I use regularly, as well as the one from the UK, which I also use, and the one in Canada. Those are three models that provide, with their own respective delays and so on, but provide an effective means to have access to information and records. And second, as importantly, perhaps even more importantly, you have to have a police that police the police. And unless that happens, until it happens, you're kind of spinning the wheels. And finally, if you do, and if you don't already, make sure that you take the occasional journalist to lunch and making sure that you become friendly with him and encourage him to do the duty to which his profession calls him for, that is to report upon and to develop the public interest. Thank you very much.